Thanks, Scott, and thank all of you. It's 7:12. Good grief. This is a serious dedication to the law, and I do appreciate it. There are connections between all of these cases, and I'm sort of noticing one as we go along here, which is that each one of the cases that the Supreme Court takes seems to have implications well beyond the narrow issues that it presents. Right? JD mentioned that, gee, it's nice that we have the right to counsel within a trial, except that given that the guidelines have set the penalties for going to trial so high, rational people will plead out almost all of the time. No cases go to trial anymore. Everything settles out. Eric said, well, gee, isn't it interesting that we probably are going to allow the FBI to put these devices under people's cars? And there's a recent stir you can see on the web where somebody actually caught the FBI doing this. And so you can get a nice little set of pictures about what these devices look like. If you're at all interested, and the thing is that the court is going to be deciding an issue that has nothing to do with those rather tube-like devices inserted badly in the undercarriage of your Buick. Really, those cases are about your cell phone, which can and have been tracking your location within 1 meter of an accuracy since you bought them. And the question is, can the police get that information without a warrant? The answer until now is absolutely yes. So when I say something like, Golan is about whether or not German movies out of the 1940s and 50s and some Shostakovich, that is, works produced by European artists primarily, are going to be in or out of the public domain, your immediate response should be, why am I still sitting here at 7:15? And my answer is that it has a lot wider implications than you might originally think. The basic deal of the public domain is this. I can whistle any song I want right here in front of you. You can think whatever you want. If you're listening to music, you're making a mental copy of it in your mind. If you read a book, you can take your impressions of it away with you. You can even turn it into your own book. The public domain is the terms of a basic deal. The deal is this. All of us give up something of enormous value. The idea that we can just use ideas, music, songs, other things that come to us, books, written words, famous quotations. We're going to give up our right to do that. And the reason that we're going to give it up is so that the authors and inventors of those works can recoup the cost of creation of those works. Because if we didn't protect them, what would happen is I write the great American novel, okay, it gets panned by the press, nobody cares, fine. You write the great American novel, and it's an enormous success. And the problem is that somebody else can immediately come along and copy it, and they can always undercut you because they didn't have the cost of writing the book. You did, they can always undersell you. That's the problem. So we solve a problem of competition law through the profoundly anti-competitive measure of giving state-granted monopolies to people. Think about it. Our law of competition is based in monopoly. We give state-granted monopolies to the creators of these works. Now, there are two issues. The first issue is the Constitution says that Congress gets to do this in what's called the Copyright Clause, or sometimes the Progress Clause. The Congress gets to do this for limited times. And we don't know what that means, except that what it doesn't mean is that Congress can't keep extending the term of copyright for 9 times running now, so that Mickey Mouse will never fall into the public domain. And that's why one of the acts challenged in the under case in Golan is the CTA, the Copyright Term Extension Act, which extended copyright terms from life plus 50 years to life plus 70 years. It's colloquially known as the Mickey Mouse Protection Act. The other one, though, that is much more an issue in Golan is the URAA, that is the Uruguay Round Implementation Amendment, and the Uruguay Round Agreements Act And what it does is it enacts our treaty obligations to protect copyrighted works in the United States in the same way that they would be protected in their country of origin. And in some cases that means that works that fell into the public domain in the United States are now going to be taken back out of the United States public domain. Now this is all complicated by the fact that the Supreme Court has more or less recently seen this. In a 2003 case called Eldred, we used the progress and limitations language to say it can't possibly be that limited times means always 10 years in the future, right? I mean, my daughter Hannah has caught on to this. What does tomorrow mean? Never, right? We'll talk about this tomorrow. Hannah's wise to this. She said to me this morning, we're going to talk about it today, Daddy. Okay? My 5-year-old gets it. Somehow the court doesn't. We should say something about what's going on here. I think what's going on is that courts are treating this as a political question. That is, they don't know what time ought to be the right amount of time to give an inventor in return for the deal that we as the public grant for them. But they're not about to sort of split hairs between 50 years and 70 years. At some point, though, it's got to stop. Not likely to stop anytime soon, unfortunately, as we're seeing in Golan. So Golan is the next test of this. And the lower court decisions do bring this Copyright Term Extension Act claim, saying, listen, under the Copyright Clause, you really can't keep looting the public domain. I like how Scott put it earlier in the conversation with me. Eldred strangled the public domain, right, by saying we're going to extend the term of copyrights from life plus 50 to life plus 70, which means that nothing new in your lifetime of consequence has passed into the public domain. I'll say it again. Nothing new of consequence has passed into the public domain in your lifetime, nor is it likely to. The last person you can read is H.P. Lovecraft. Because some of this stuff made it before the time, before this change in our culture. After it, forget it, Jack. Nothing new. Okay. So that argument, though, the strangling of the public domain was Eldred, the losing of the public domain, that's Golan. The idea is, can they take things that weren't already covered and just extend the coverage longer, right? Now we're taking things that weren't covered at all. And we're taking them back out of the public domain, and we're saying they're now retroactively protected. And the people who sued, who are not your usual people who don't get much of a hearing before the Supreme Court, these are opera conductors, right? These are movie houses that wrote movies based on European films that have passed into the public domain because we didn't have agreements with Russia until fairly late in the game, right? These are movie houses, these are opera productions. These are the basic centers of the production of culture that we often normally give a large amount of expressive protection to. And that leads to the fighting question in Golan, which is not the limited times clause, although you'd think it would be obvious that continuing extensions is not a limited time. We lost that one. And so now the question is, does this removal, does the looting of the public domain implicate our free speech rights? Right? There's just too many opera singer plaintiffs in this case for the court not to take seriously. And Scalia goes to the opera. My wife's an opera singer. Saw him there. Had a wonderful conversation. Right? So there's he's a very kind person. So there's just the court's just not going to say the First Amendment has no implications here. And the idea goes something like this. You're removing people's ability to express. Not just express in the court's sort of old school way, that is, put on a Shostakovich performance, but express in the way that you and I and the new generation understand it, which is mashup culture, right? The ability to use bits and pieces of other things. That is, the ability to write important works like Pride and Prejudice and Zombies. And if you haven't read Pride and Prejudice and Zombies, you need to read it, because ninjas are also involved. It's beautiful, right? Mashup culture. We are children of mashup culture. Web 2.0 is about the mashup culture, and mashup culture needs the public domain or some version of it in order to function, in order to use the building blocks for building this new kind of intellectual property. Okay, so that leads me to draw to my conclusion. I don't think the court's going to have sort of a conservative originalist moment on the progress clause or the copyright clause. That would be the only chance we would have, is if sort of Thomas and Scalia suddenly came out and said, wow, it says limited times. That can't mean forever. They're just not going to say that. All right. Then the other one would be, okay, let's apply the First Amendment interest. Here the problem is that the regulation is content neutral. And as we all know, content-neutral speech regulations get sort of a pass, right? They get intermediate scrutiny, and intermediate scrutiny is deadly because it doesn't require the least restrictive means test. It just requires a narrowly tailored means test. That is, the means that Congress picks has to fit to the goal that Congress had selected. And even though there are less restrictive means of doing this, the United Kingdom, for example, is going to go ahead and let people who've been relying on the public domain marks keep using them until they get bought out by the original rights holder. That would be a less restrictive way of doing this, rather than what the U.S. statute does, which says, all right, all you people putting on Shostakovich Productions, you have exactly 12 months. After that, we cut you off. You can make no more copies. You can simply continue to perform for a 12-month period. So our system's fairly draconian. There is a less restrictive alternative, but because there's intermediate scrutiny that's likely to be applied, forget it. The court's not going to do much with it. I do want to add one last thing, though. Mashup culture. That's our culture now. The enormous flowering of what everyone does, people putting stuff up on Flickr, right? People mashing up music, girl talk, all this kind of putting together bits and pieces of culture and creating something new. We've had to recreate the public domain. If Eldred and Golan killed the public domain, that is, they used nuclear weapons on the public domain, they destroyed it. The thing is, the rest of us have responded with biological warfare. We've responded with a series of contracts called the Creative Commons that creates, if you go on Flickr, you'll see it, a set of license terms that tied to what used to look like public domain stuff, pictures, music, stuff that people want to let everybody else use freely. The problem with that kind of license, though, is that it is a viral license. Think about what this means. These licenses that defend the new public domain, the Creative Commons, mean that wherever the idea goes, wherever the picture travels, wherever the movie clip goes, whoever uses it is also bound by the license term. That is, the license travels with the intellectual property and binds whoever it touches. That's good in one sense. It defends the public domain. If corporations now try to take out of the Creative Commons and steal from it and build their own code, they can't do it anymore, because if they use Creative Commons code or GPL code to build something new, the new thing that they build goes right back into the Creative Commons, it goes right back into GPL. It poisons the well. It tells them to knock it off. Stop looting the public domain. Okay? But the problem is that corporations have also learned. Think about what a viral license means. Whoever comes into contact with the embodiment of the intellectual property is bound by its terms. That means you don't own your phone. You don't own your PlayStation module. You will not in the future own your car. Why? It's got software embedded in it. The software has license terms and conditions that travel with the software. So in a lot of senses, these cases are not going to do anything wildly interesting. We're going to loot the public domain. I'm far more worried about and interested in what the rest of us have done to create a space that we can commonly create things with, where we can use each other's ideas, and the legal tools that we built to permit that to happen. And now, the first cases that we're beginning to see, the misuse of those viral contracting tools that we use to create a new public domain. Cases like Golan killed the old one. Thank you.